Welcome viewers to the PI Show. This is the show that talks about everything that's in personal injury law today. I'm John Carancis. Tony Carbone is on a well-earned break. We'll see him in a few weeks' time. With me tonight, Nadine Hanna. Nadine, how are you?
Hi John, hello viewers.
And Don Mafia. Don?
G'day John, g'day viewers.
Viewers, tonight we're going to talk about work cover, the basics of work cover in the Victorian scheme, and the Transport Accident Commission and the rights that individuals are entitled to when you're injured in a car accident. However, before that...
John, you've been dying to talk about this.
What's in the news?
What is in the news? And what has been in the news for the last, nearly coming up to 8 months, the start of the year?
Don, the Bombers.
The Bombers.
They've been charged by the AFL for bringing the game into disrepute. James Hird, Corcoran, the club itself, the doctor,
Bruce Reid,
and Mark Thompson, the assistant coach. These are big, big charges.
John, timeline, we've got ASADA has brought down their interim report, not full report, interim report. AFL have received that report and now decided to charge not only the club, but also go after the individuals.
We've also got the situation, Don, whereby there's an argument from the Hird camp where they want Mr. Demetriou and the AFL Commission to literally stand aside and to be an independent public hearing about this. Yeah. Now it's... I can understand the AFL Commission at the moment they're saying, no, we will not abdicate our authority in this regard. We can charge you and we can determine the matter. The rules of natural justice, Don. What about that?
Exactly, it was a fair hearing. Now, the thing is, John, you've got going after the club. And now, if we look at what sanctions can go on a club, we can look at fines, you can look at points, premiership points. I mean, we look at what happened historically to, for example, Carlton. You know, they lost the draft picks and fines, and that destroyed the club. The problem we have now is they've gone after the individuals.
Yes.
So the stakes are much higher for those individuals. James Hird gets suspended. If that's a sanction that might be given down to him, which seems likely if that's going.
It is.
He's off, let's say, 2 years. He can't coach.
Well, that'll destroy his reputation.
So that's why James Hird has gone out.
He's
all
fighting.
Guns are blazing.
He's fighting. He's got Jack Rush QC, I understand.
And Burnside, and QC.
Burnside, the eminent human rights lawyer. It's going to cost him a lot of money.
Well, it is, but his whole reputation, his whole career is at stake for this, because if he gets suspended, unfortunately, there goes his whole career.
Now, at the same time, Thompson has on television admitted that he might be 5 to 10% at fault. An admission is an admission, isn't it, Don?
Well, that's right. Doesn't mean he gets 5 or 10% of the penalty. We don't know, but still, there's so many things unanswered, John. Do we know if this AOD that they were given to the players was it banned? It's coming out now that it wasn't banned by ASADA.
That's part of the defence of the Essendon Football Club, that no one can show what the players were injected with.
Well, they know there was an AOD, which now is coming out, may not have been banned, not banned, but the other substances that have been injected, they don't know.
Yes.
And then you've got this allegation, John, you know, you've got some photos there.
Oh, yes. The allegation of a man in New Mexico, not Mexico, apparently it wasn't Mexico, but now in New Mexico, which is apparently a state in America.
It is a state in America. We're talking about, John, where all the Western films were filmed.
Apparently. He's brought back this drug, and for that, because he suffers from muscular dystrophy, and the players were injected with this drug.
It's just, it sounds like a ludicrous sort of allegation.
And then you've got supporters of the Essendon Football Club and going to the game with this banner, Olay Bombers. What's going on that? Is that bringing the game into disrepute also, Don?
Look, in my view is that, well, since this news broke, which was, I think, John, would go back to start of the year, around before the season started.
January.
Since then, every day, every week, we have ongoing news coverage about these allegations, about what's occurred, what's happening. You've got one camp, James Hird camp, saying one thing about Demetriou. You've got Demetriou saying another thing. It's just the whole thing. Isn't that, since that started, and since no one can really say what's going on, and we know that the corporate governance of Essendon was criticised,
Well,
isn't that just, even that bit, those last 8 months, isn't that bringing the whole game in disrepute?
Exactly. And then you've got Essendon supporters turning up to the game dressed in with their Mexican hats on.
That's right. Now,
Look, I know Nuncio was supposed to be here today, but when I said that I'll be bringing the Mexican hat along, he said, no, I can't come along. But look, it's just the Ziggy Switkowski report also is damning on what the corporate structure of the Essendon Football Club was.
that's right. The
Now,
corporate governance.
if I was the AFL presiding on this, I'd be relying simply on that report, Don.
Well, they can. They can rely on anything, it appears, John.
Exactly.
I mean, look,
They have to
unfortunately,
abide by the rules of natural justice.
that's the argument now, isn't it? That's
Well,
what
they do.
Hird is
It's-
saying, and good on him.
Otherwise, an injunction
fair
in the
hearing.
Supreme Court of Victoria could at any time be issued by any of those parties, James Hird in particular, to stop the AFL Commission from hearing the case.
right.
There's a lot of people that are interested in what's going on, but most of the viewers, most of the people out there are like yourself, Nadine. They just want to get back to the football.
Yeah.
Simple as that.
They just move on. I mean, this has
Just
been
simple
in
as
the
that.
papers for the last 8 months.
This has been going on
Move
for
on.
too long.
It's been saturated,
It's
unfortunately.
been
It has been saturated.
And unfortunately, the lawyers have got involved.
Yep.
And Don, and we all know what happens when the lawyers get involved. The legal expenses increase.
And the litigation gets protracted, unfortunately,
Protracted.
sometimes. Well, in fact, in this case, the hearing was supposed to be soon, and now we don't have a date, so we
And
don't
parties,
actually know.
parties become entrenched in their positions.
Yep.
Instead of trying to resolve the matter by compromise, we've got all these different camps attacking each other, leaking details out. In the end, the Commission has
have to
to
determine.
determine at an open hearing what's gone on, and if the sanctions are involved, sanctions are involved. But Don, one other question. Once the sanctions are handed down, do they have rights of appeal?
I think they do, John. I think they will.
Can they go to
can
the
injunction-
Victorian Supreme Court of Victoria?
They can, John. They can go to Supreme Court and say that sanction was unfair.
Exactly. We'll come back to this, viewers. It's an ongoing story, and I'm sure Don and Nadine, it won't finish soon enough.
unfortunately not.
Parking fine under fire.
Yes.
What's going on with the City of Melbourne fining a lady that parked in a loading zone? What happened here,
Well,
Nadine?
it seems that she had parked in a loading zone to report an accident to the police, John, and I was actually slapped with a relatively hefty fine for doing so.
Now, the lady's name, Frida Theodorakis, she received a fine, as you said, Nadine.
Yeah.
The council, the City of Melbourne, has taken her all the way to the Magistrates Court of Victoria to collect their $141 fine, Don.
And the thing is, they had the triple load core
They had the
above it, so she was all confirmed what she was doing. Problem is, John, as we know, if you're parking in a no parking zone, loading zone, it's a strict liability.
Yes, but
Give
Don,
attention and all that. So
But-
she was she actually had to plead guilty, but the magistrate said, well, you pleaded guilty under the circumstances, however, no fine, no conviction.
so the magistrate rightly chucked this case out. Now, there's questions about why was she prosecuted?
Exactly right.
Why
And
did the City of Melbourne prosecute her? Now, fortunately, the Lord Mayor has asked for an investigation in regards to this matter, and I congratulate him on that. But it's just another case of bureaucracy gone mad, isn't it, Dom?
I think so, and the amount of money they would have spent to prosecute it, John, just outweighed the benefit of it.
Thousands of dollars.
Yeah, where's the
Thousands
public
of
policy
dollars.
come into that?
And
So
on top of that, she's helping the public, helping the police.
and she was helping, even worse.
Look, viewers, we'll have a short break. After the break, we'll go into work cover and transport accident law and give a short introduction and a short back to basics about those schemes. Thank you. Tonight we're going to talk about work cover and transport accident law in the state of Victoria. In this segment, we're going to talk about work cover. In particular, what your rights are when you're injured in the course of work. Nadine, when a worker is injured in the course of work, what happens next?
Well, firstly, John, he has to submit a work cover claim form to be able to ensure that he can get his weekly payments and medical and like expenses covered. Now, firstly and more importantly, he does have to meet the definition that he is a worker under the Act. Now, it could be that he's working wholly and predominantly for a subcontractor, or that he's owning his own business, or is employed by somebody else to be able to do this type of work.
Nadine, what about if the injury is his own fault?
It doesn't matter, John. Under the work cover scheme, to be able to attract the weekly payments and medical and like expenses, it's a no-fault type of benefit, and that will ensure that he is covered for those types of expenses. It will make a difference a little bit later on should we ever have to investigate and advise whether or not there are damages and common law claims for the individual.
So we're talking about a claim for weekly payments of compensation.
That's right.
Medical expenses and a lump sum claim.
That's right.
But John, don't you also have to report it to your employer? The accident has to be, or incident has to be reported to the employer.
It does, and it has to be technically within 30 days of the injury. You need to report the injury to your employer and literally fill out the paperwork and make a claim.
So let's say if someone's bent over, hurt their back, thought, I'll be right, and it's not reported, they should, even if they've injured and think they'll be right, they should still report it to their employer.
Exactly,
right.
because
That's
otherwise that injury that you think, oh, that'll be okay, a lot of times 6 months later comes back to, no, it's not okay.
And we see it time and time again, don't we, John? People in Nadine, people who have been injured, first thing you ask them, have you reported to employer? No, or waited 6 months. And then you've got the issue of causation.
That's right, that's right. And it's also important as well to mention that if you do get injured, it's really important to go to your GP and make sure that the GP also is aware of that injury having occurred at work.
So viewers, once the injury has occurred, you've reported it to the employer, you've filled out the paperwork, the claim form, you have to go to your GP to get what's called a certificate of capacity, and then you lodge the claim with the employer. Now, the employer has a certain amount of time, less than 30 days, to say yes or no in accepting the claim. Nadine, what happens if the employer says nothing after 30 days?
The claim is deemed to have been accepted, John, so the employee is automatically receiving these claims for weekly payments and medical and like expenses.
So viewers, you must lodge the written paperwork. Now, it can be complicated. So that's where you might want to see a lawyer straight away. You might want to ring a lawyer up and say, look, I've been injured at work, what do I do? And that's where a prudent and a good personal injury lawyer will assist you in making a claim. A lot of times you don't need to do that, but if you don't feel comfortable in filling out paperwork, if you're not fluent in the English language, well then you need that assistance. Now Nadine, let's say the claim's been accepted. You're a worker and you can't work because of this work injury. Let's say it's a back injury.
That's right, okay. So the worker will then, like we said, John, will be receiving these weekly payments for a period of 130 weeks or 2.5 years, as long as he is incapacitated for his pre-injury role. So it could be he's unable to perform modified or alternative or unfit for all duties. As long as he's not fit for those pre-injury work, he can get those weekly payments.
So the worker receives for the first 13 weeks of weekly payments, 95% of his pre-injury average weekly earnings.
That's right.
And thereafter, it drops down to 80%. So there is a bit of a loss, but viewers, if you're a part of the union and your union has made a deal with the employer for make-up pay, then you should get the union involved, and literally the employer should be paying that make-up pay, which is that lost 20%. So, Don, we could have a situation where you're off work, but you're still receiving 100% of your weekly payments.
That's correct. So always inquire with your employer, but also look at your superannuation funds, because it can also have that top-up make-up pay. But more importantly, seek advice from your unions as well. But the 1 for 30 weeks that you're talking about, that's accumulated, isn't it? It's not starting from the date of accident, it's starting from the date that you're off work.
That's right.
So is it a situation where you could be injured, still at work for 6 months, and then take time off, and that's when the 130 week starts?
Oh no, not necessarily.
No?
No.
So it could be from start of the injury?
Exactly, yes.
Oh, wow, okay.
Exactly.
So that's what difference with, and we'll talk about after break with the TAC. I'll go to more.
Nadine, lump sum claims. What's that
Yes.
all about for WorkCover?
Well, given that a claim has been accepted, a worker is entitled to put in a small lump sum claim within 12 months after the injury, provided that the client has not received any type of surgery, so his condition is stable, John, and that a body or a whole person, what we call a whole person impairment, will be assessed and attributed with a percentage of a figure money, a settlement money.
So we've got that lump sum claim, which is called the 98C impairment benefit claim, but then we've got what's called the serious injury application
That's right.
and common law damages claim. Viewers, that's all about your rights to sue the employer for the injuries you sustained in the course of your work, and that it was the fault of either the employer or another party, and because of that injury, you are no longer able to work, and that you're entitled to past and future economic loss and past and future superannuation losses, Nadine, and pain and suffering damages. We recently settled, Nadine, a case for a young worker who lost his foot in a work accident. The total amount was over $1 million in settlement.
That's right. It was
Now,
a significant case.
It's a big case. These are the type of monies that can occur when you're injured at work and it's not your fault. The statutory maximum for pain and suffering, Nadine, has just been increased to $555,000 in the WorkCover scheme. For economic loss, it's $1.275 million. That is the stat max. You can't get more than that, viewers. So if you're injured in the course of work and you can't work, you have a lump sum claim, especially if you've been injured and it's not your fault. If it's your fault, then your damages case will be an issue, won't it, Don?
Well, that's right. You're left with those benefits, those no-fault benefits, so the medical expenses, the wages and the lump sum. But John, to get access to this damages claim, what do you need?
You need to have what's called a serious injury.
Yeah.
You need to have one body part, let's say the back, that has so severely affected you that the consequences of that injury have really been adverse to you and changed your life. And viewers, we'll now have a break, but after the break we'll go to the transport accident law in Victoria. Please stay tuned. Welcome back, viewers. This segment is about transport accident law in the state of Victoria. Don, you're the expert. Tell us what happens when you're involved in a transport accident.
Okay, so if you've been involved in an incident directly caused by the driving of a motor vehicle, that's the definition of a transport accident. That's a motor vehicle, tram or train. So not necessarily four wheels, can be the train carriages falling over caused by the driving of a bus or tram. So if you're injured in those circumstances, you lodge a claim with the TAC. TAC is the compulsory third-party insurer in Victoria. So all your Victorian viewers, when you pay your registration, you pay a TAC premium on top of that as well. And it covers you, if your claim's accepted, covers you for what we call those, keep calling no-fault benefits, John. Now, Dean, when we say no-fault benefits, what do we mean by no-fault benefits or statutory entitlements?
Well, Donna, all it means really, it doesn't matter how the accident or who's responsible for the accident occurring. It means that the worker then is entitled, just as long as I should say that it happened within the realms of the TAC and all the work cover provisions, then the worker or the victim in TAC is entitled to receive these benefits.
So the benefits are, again, loss of earning capacity benefits,
Well,
your wages.
loss of earnings and loss of earning capacity benefits, which go for a period of 3 years from the date of the accident. They start on the date of the accident,
Yes.
and it's generally 80% of your earnings, and there are maximums, minimums, and the like. So they're paid for if you're unable to return to work. Also medical expenses. Medical expenses are paid for life, as long as it's reasonable related. If you're in hospital for more than 1 day, they start paying medical expenses straight away. If you're not in hospital for more than 1 day, it generally means overnight, there is an excess payable. Like every other insurance policies in the country, there's always an excess payable. For medical expenses in TAC, the excess is $584.
So the transport accident victim has to pay that excess first.
Well, they incur it, John. So if you go to
All right.
Medicare, Medicare pay for it.
Okay.
For the wages, and I think it's gone up, sorry, I said 584, but it goes up every year, so it might be...
An impairment benefit, what's all that about?
Yep. The impairment benefit is a lump sum paid if you sustained a permanent impairment. Similar to work cover, if you sustain a permanent impairment with more than 10% impaired, and according to guidelines, you get a lump sum. Okay. So they're generally the no-fault entitlements. Viewers, you've got to be sure that there are strict time limits to lodge a claim. There is, like, for example, a 12-month time limit to lodge a claim, or there's a further 2 years to do so. And you also have to report the accident to the police.
Don, about lodging the claim, what happens if you don't lodge a claim for 2 or 3 years?
After 3 years, no entitlement.
Really?
Yep.
That's it?
That's
Wow.
it. From
You're
the date of the accident,
precluded.
nothing.
So viewers, you must lodge a claim when you're involved in a transport accident. You must ring up the TAC and lodge a claim.
That's right.
Is ringing up the police enough?
No. You have to report it to the police,
Yes.
and you have to ring the TAC.
All right.
And see the doctors. But John, let's talk about the common law, because we
Yes.
spend a lot of time on no faults, right? In Victoria, people have a right to sue if they prove 2 things, right? So we're talking about work cover and TAC now, because they're similar. One, as you just said before, John, fault, right? You got to prove someone else at fault, right? And 2, you got to show that you've sustained a serious injury. Nadine, we keep saying serious injury. What is a serious injury?
Well, it's serious injury with either a deemed serious injury, as we had talked about within the meaning of the whole person impairment, or alternatively, Don, under what we call the narrative test. So you have to prove that your injury, whether it be a back or a shoulder or your neck, is serious within the meaning of the law, looking at your incapacity to work, so your loss of wages, and alternatively, together with it, what the pain and suffering consequences are. So we have to really tease out what those consequences really are for the individual worker.
So Nadine and Don, it's an assessment of the injured party of the consequences of the injury upon them.
That's correct. So you're looking at their lifestyle, recreational, leisure, domestic, social activities.
How it's all been affected.
Had been affected.
Now, what about if you've got someone that has been injured, but they're still working away, earning good money? What do you think of that case?
Well, firstly, under TAC, the TAC is just that one test, really. So that is even people who are returned to work. Now, I've acted for many people who have returned to work. They still have a serious injury because of the consequences on those other activities I just described, the leisure, social, domestic activities. Work cover will be a different problem. Please explain it.
Yeah, there's a different issue there, and this came up in a recent court decision of Judge McInerney of the County Court of Victoria, whereby the plaintiff worker, Joe Noonan, who was part of the police force for years, claimed severe behavioural disturbance as a result of the activities, the work activities at work, seeing dead people, seeing all these type of activities. Now, he says he suffered from stress, anxiety and depression. Now, at the same time, he was earning really good money, over $200,000 for a different employer. He was well enough to write or dictate 10,000 words for a book that he's about to publish. The judge found in that case, Nadine, that he had not suffered a serious injury.
Well, and it's all about, like we said, John, it's all about consequences. So even if the worker has returned to work in any type of employment, if he hasn't lost what we call 40% of his income, we can rely on that pain and suffering consequences. But in this case, John, he's gone, it seems that the type of diagnosis that he had, what we call severe psychiatric disturbance, may not have necessarily met, or the judge wasn't satisfied that he had met that test because of, you know, it seems that he was still maintaining relationships in an adequate way, gone about going to the gym, written a book. So it seems that he was relatively well adapted.
The judge in that case did not find that the medical reports accorded with his real life.
Now we should point out that if you're talking about physical injuries, it's a serious test.
That's exactly.
When we talk about psychiatric, which is another limb of this serious injury test, it's actually severe, so it's more than serious. So it's a higher test.
It is a very high test.
Don, that case is under appeal, but at the same time, it's just a classic example of this is the type of assessment that a judge will make for a worker or a transport accident victim as to whether or not you have suffered a serious injury.
That's correct.
Now, once you're given a serious injury certificate by either the Transport Accident Commission or the Victorian Work Cover Authority, well, ideally there are negotiations on foot with those parties. Again, you have to show viewers that the injury was not your fault. Otherwise, damages are problematic, aren't they, Don?
That's correct.
Viewers, the scheme, Work Cover and Transport Accident, is very complicated. You need to seek professional advice from a personal injury law firm and expert lawyers. Thank you, Don. Thank you, Nardine.
Thank you, John.
Viewers, as Tony Carbone would say, stay safe.